Hello everyone, my name is Luciano Oliveira. I am a Brazilian attorney, also licensed in Texas and California, and today we're going to be discussing about how a probate works in Brazil and whether you also need a probate in Brazil in addition to a probate in another country such as the United States. First, let's talk about which route you're going to pick in Brazil. So if there are assets in Brazil, most probably you also need a probate in Brazil. Even if the deceased was living in the United States with assets in the United States, and this would be the same thing for a different country, if there are assets in Brazil, a probate in Brazil would allow a court to understand which assets belonged to that deceased person and to authorize the change of title for each of those assets. In Brazil, we have two different routes for probates. One route is like the court route, and another route is going to be the registry, and the registry is known as cartório in Brazil. The cartórios represent a faster route. Unfortunately, it's usually not available to any probate with assets in more than a single country. Also, if the probate has minors involved, you're not going to be able to use a cartório. So in our experience, the vast majority of cases involving foreign citizens are going to be resolved in a court of law. Naturally, to postulate to make a claim to a probate in Brazil, you're going to need a Brazilian licensed attorney. A U.S. attorney, for instance, has no capacity to postulate in a Brazilian court. Also important to note that, unfortunately, court probates in Brazil usually are going to take a long time. So let's talk about probate. What is a probate? Probate is also known as inventário in Brazil, and unfortunately, many people are going to translate an inventário as an inventory, right? Because inventário and inventory, they are kind of close and similar, but obviously an inventário is a probate, and a probate is going to involve the collection of assets, and the court is going to try to assess all the assets that were owned by the deceased, and after the court knows exactly all these assets, the court is going to also try to understand if there was any debt, and after the court assures that all the taxes and debts are paid, then the net proceeds are going to be distributed among the heirs. Making sure we answer this question, do I need two probates? And again, as long as there are substantial assets in Brazil, in 99% of the cases, yes, it does not matter if the vast majority of assets are in a different country. Brazil is going to require you to open a probate in Brazil to, like I said, give proper destination of such assets, particularly observing the Brazilian law. Following the Brazilian law is the reason why, once the court knows that there are assets in more than one country, the probate should be done through a court by a Brazilian judge, with parties being represented by Brazilian attorneys. Brazil may have substantially different laws when it comes to the distribution of assets, and therefore the concern from the legislators and the court system in Brazil that a Brazilian court is adjudicating the probate. So let's now talk about the foreign citizen's perspective of a probate in Brazil. The inheritance laws are not the same, and the main distinction is the so-called forced heirship. That means at least 50% of the assets of the deceased should be distributed according to Brazilian law, meaning that the deceased, if they had a will, the will would be compelling the distribution of assets of only 50% of the total assets. In other words, 50% discretionary and 50% as mandated by the law. This Brazilian regime of asset distribution will certainly be activated whenever there is a Brazilian party in the loop. If there are only foreign citizens participating in the distribution, maybe the judge will adjudicate the probate in accordance to the laws of the United States, but that would require a very strong representation of the Brazilian lawyer. At the end of the day, the vast majority of Brazilian judges have no clue about how a probate works in the United States, and therefore it is pretty difficult for one to make a case on how the assets should be distributed in Brazil if not in accordance to the Brazilian law. A common question we have here at the firm is for prospective clients to ask us, should I have my own representation, meaning should I hire an attorney in Brazil to represent me, or should I have, for instance, locals in Brazil representing my interests? Very common for, mixed families in which the deceased would have children in the United States and children in Brazil. So our answer is going to be usually it depends on whether you trust like the locals or if the inheritance is of a substantial amount. Usually, if the U.S. client trusts the Brazilian locals and the assets are not that substantial, this may be a reason for the U.S. parties to trust the locals in Brazil to handle the probate and avoid additional costs. However, if the assets are substantial or there is a somewhat mistrust between the U.S. parties and the Brazilian parties, it may be a reason for you to secure a Brazilian attorney to represent you in the probate. There is no need for a single attorney to represent all parties, and in large probates is more common actually for multiple attorneys to participate on behalf of multiple parties. This said, it's very important that these different parties try to work along each other, because disputes between the parties may result in a long delay in a probate, usually several years of delay. I hope this video was helpful. If you have questions, consider scheduling a consultation and follow us for more tips.